Liberty Nation with Tim Donner.
And now we have reached the portion of Liberty Nation Radio which we so desperately need in these times of Marxist revolt on the streets and chaos and bedlam. We need to restore some order. We're going to do it here on the show by reintroducing our guardian of individual liberty. He's the legal affairs editor of LibertyNation.com, constitutional lawyer, back with us again, Scott David Cosenza. Hello, Scott.
Hello, Tim. Thank you for that introduction.
Well, a lot that you need to protect us from, it, at least by informing us of the threats, which we hope to do in a unique way kind of here on the show, because these kind of stories that you cover tend to be overlooked. Now, one thing that wasn't this week, but which you pay close attention to as a constitutional lawyer, the Supreme Court of the United States overturning a Montana ban on money to religious schools.
This has the potential going forward to be a foundational ruling in school choice, Tim. Montana had a system whereby people could take a tax credit if they, I think it was $150, if they gave that much money instead of fulfilling their tax obligation to that tune, if they instead wrote a check to the scholarship fund, they could get out of paying that tax. So as a way to fund the scholarship funds with private funds, but it's a tax credit, so you're getting a relief on your tax. The problem was the people who got those scholarship funds, they could use them in private schools in Montana, families, and they tried to use it at a religious school, and the Montana Department of Revenue that was administering the program said absolutely not. The case is Montana v. Espinoza. And Ms. Espinoza has a kid, a daughter, who wants to use this scholarship to pay for a religiously affiliated school. State says no, they sue. Montana Supreme Court, Tim, says the Montana Revenue Department was correct in its finding that you can't pay this money to a religiously affiliated school. But also, that's illegal and violates the Establishment Clause and the Free Exercise Clause. So the whole program now has to be shut down because of that. All right. Then it goes to federal court. We get to the Supreme Court, which came down with its decision this week. It's a 5-4 decision, and it says that the killing of the program in order to satisfy basically that it not discriminate against religious schools was incorrect, and that killing itself violated the right to free exercise and the Establishment Clause. So this Montana now has to restart that program and allow those funds to be spent at religiously affiliated schools. Roberts voted with the conservatives this time, so it's Roberts, Thomas, Aledo.
You can toss a coin with the Chief Justice. Huh? One time he's with the liberal bloc, the next time he's with the constitutional bloc.
Somewhat of a surprise came from the left side of the bench, Tim, when Justice Ginsburg did not vote. The liberals did not vote as a bloc. Justice Ginsburg wrote separately, and hers was more of a procedural objection. And Breyer and Kagan voted together, and Sotomayor kind of wrote separately as well. Also, even in the conservative side, a lot of the justices wrote their own individual opinions. I think that Elena Kagan and Brett Kavanaugh are the only two justices who mercifully thought that we didn't need to hear from them individually on this issue. But it's very important because of what could happen from it. This one Montana program is very small, both in terms of dollar figure and number of human beings who are participating in it. It's the broader scope of what this means going forward, to build on this, to then perhaps get competition that allows people to take a voucher that the state gives them and go to a Catholic or other religious affiliated school and say, with the taxpayer dollar, educate my kid.
Basically, so people's kids aren't imprisoned in failing and dangerous inner city schools with no choice. I mean, this is something that's heavily supported by the black community. 80+%. The Democrats stand against it, and yet they keep voting for Democrats.
Whenever they have one of these lotteries that one of these horrible neighborhood school people get to send their kid to like a private academy, there's a line around the block just for the application.
They're overrun.
And I talked to Dick Comer, who is the lead attorney for the winning side, who's an attorney for the Institute for Justice, or rather he was. He retired since the case was filed. But what he said to me was that he actually thinks this will improve public school if more competition is allowed, just because of how competition improves everything always.
It's simply human nature. And that hasn't changed, Scott, best I can tell, since the dawn of man. Now, SCOTUS also weighed in with an action that they didn't take. And here's where Chief Justice John Roberts comes in again. They overturned a Louisiana abortion law, scuttling the dreams of pro-lifers, and it's all on Chief Justice John Roberts. If you listen to the people who are disappointed, anywhere from disappointed to infuriated at their failure to uphold this law.
So there was a Texas decision a couple years ago where the Supreme Court overruled almost an identical law. Okay, and that the law we're talking about here says that an abortion provider has to have admitting privileges in a hospital. In this case, I think 30 miles from where their clinic is. Now, the legislative history on this basically says that they want to do this to frustrate the rights of abortion providers and those women who would seek abortions. This is not, as so many they proclaim, about women's health, for instance. Except for the fact that in a more global sense, they might argue that it's healthy for women to not have abortions, but they don't say that because that would be against Roe v. Wade, and it would be stricken down. So what they do is they try to couch it in some sort of thing like that there's unqualified people performing abortions or something like that to try to get that hook, that medical hook. So anyway, the Supreme Court overrules that Texas law and says no way. Louisiana passes an almost identical law. And somehow, Tim, in the Fifth Circuit Court of Appeals, the Fifth Circuit upheld the law as being constitutional. I can't understand, just like the dissenting justice on the Fifth Circuit of three who ruled, I think, the right way, which is Supreme Court precedent in this area was crystal clear. So rarely do cases ever get to the Supreme Court. I mean, when I tell you that they modeled the one law after the other one, that's not a fabrication or hyperbole.
By all accounts,
it is
that's
almost
true.
like a word
almost
for
identical,
word.
Yeah.
So
it's a copy and paste.
So the idea that kind of a challenge would get back up to the Supreme Court so soon after just being ruled on is a very odd thing. We don't have that. And so that's why, Tim, people were saying perhaps this could be a chance for a real sort of inroad against Roe v. Wade. That would be if Justice Roberts, for instance, wanted to go that way. There's a strong feeling that Justice Thomas, for instance, who's written about this, would happily peel back Roe, and Kavanaugh obviously is a Catholic, and who knows about Gorsuch, but that was sort of the feeling and why this had the potential to be a huge case.
Scott, there's also this matter of John Roberts and stare decisis, which is, respect for the precedent of the court. Now, 4 years ago, John Roberts voted against what he upheld this time. In other words, he was opposed to the decision 4 years ago, and now he authors a decision in the other direction, which does that not just prove that his loyalty seems to be to precedent in the court more than it is to his own interpretation of the law?
He is an institutionalist, and while I think his position is not correct and bad, it is defensible, I would say, that people have the court decisions to rely on for all sorts of reasons.
Thank you, Scott.
Thanks, Tim.